close, yeah. Right, tank full of gas.
All rise. Please be seated. Court calls Timoni versus Timoni, case number 2009-766749-DM.
Good morning, Your Honor. Carrie Middleditch on behalf of the defendant, Omar Simoni.
Good afternoon, Your Honor. Lisa Stern on behalf of the plaintiff in this case.
Good afternoon, Your Honor. Michael Dean, P32631, court-appointed attorney for Roe Simoni, and standing in today for the attorney of record, Karen Cook, for Natalie Simoni.
Good afternoon, Your Honor. My name is Jeffrey Schwartz, P32076. I'm here as attorney for Liam Shoshone.
William Lance at GAL, Your Honor. Thank you.
Good afternoon, everyone. You may be seated.
Sir, can you hear us? Mr. Simoni?
Yeah.
All right, sir, on the telephone, will you please state your name?
Yes, my name is Omar Simoni.
And can you tell the court where you are right now?
I'm in Israel.
All right. I called the lawyers and the parties here today to address what is in the best interest of the children. We will not argue the motion for reconsideration that will be heard next Wednesday if it is necessary. The court has one objective today, to determine the best course of action for these children. As of today, not one lawyer for the parties has offered to the court, verbally or in legal pleadings, one solution or option other than Mandy's place. This is a family court where children are the highest priority. The principles that underlie family court cases is doing what is in the best interest of the children. I have personally dedicated my entire professional career to protecting the people and the children of Oakland County. This case has garnered national attention from the news media in the past couple of days. The hysteria surrounding this case has been caused by a local media outlet that broke the story without getting all of the facts straight. Most disturbingly, that media outlet has also released the names and faces of these children. That media outlet failed to exercise due diligence in their investigation by failing to get both sides of this case. They failed to obtain a history, chronology of the events. They have failed to review court hearings and orders. There are 8 files, and no one has reviewed those files. And as of right now, no one has ever requested to watch any video. As a result, we have a frenzied, misinformed, and misguided public. It is a complete disservice to those who would want to be intelligently informed, but way more importantly to these children. It was not in these children's best interest to release their names or their faces. Any lawyer, judge, mental health professional, or caseworker who has any involvement in the family court is aware that one of the most devastating issues we face is that of parental alienation. The definition of alienation is to make hostile where previous friendship had existed. Experts have devoted considerable scholarship and research to this topic because it is one of the most difficult problems to address. Parents alienate their children from the other parent by aligning with them, sharing information which is often biased and untrue with the children for the sole purpose of having the child reject the other parent. The judicial system has very few tools to fix this problem, especially with adolescents who are taking positions based on the emotional burden placed on them by a parent. To say that they want to see one parent would place them in direct opposition to the other parent who has convinced them that that parent they want to see is the enemy. While this court's remedy in this particular situation may seem drastic and offensive, so too is the notion that children have been convinced that the only way to maintain a stable and loving connection with mother is to vilify and reject a father. The court agrees that placement in Mandy's place is not ideal. However, the court's primary concern is the best interest of these children. The decision was made so they could be put in a setting where they would not be emotionally manipulated and pressured to love one parent and hate the other, where they will receive counseling, support, and comfort in a safe place, where the message is that it's okay to love both their mother and their father. It was also a remedy the court took after 5 years of litigation and orders designed to foster a relationship with both parents. In the 5 years this case has been ongoing, the court has received no credible evidence that father has done anything to negatively affect the mental, physical, or emotional health of these children. In fact, this father has moved mountains to be able to be part of his children's lives. When the decision to temporarily place the children in Mandy's place was handed down, mother did not object. Mother's lawyer did not object. In fact, no lawyer objected. The guardian did not object. No one offered any alternative placement options. The first objection to the children's placement this court received was 2 days ago. Faced with too few options and a custody arrangement that has become increasingly harmful to the children's well-being, this court removed the children from mom's care. Despite the claims of recent media coverage, this action was not carried out as a punishment, but was instead implemented in an attempt to assist these children in developing meaningful relationships with their father. Placing these 3 children in Mandy's place was and is in their best interest. The children first came to this courthouse for a parenting time in August last year, after dozens of failed attempts at meaningful parenting time with their father outside of the courthouse. It took no less than 6 deputies, a prosecutor, various court personnel, a representative from the Department of Health and Human Services, my family counselor, and myself to finally convince the children to have parenting time with their father in my jury room. This court witnessed disturbing behavior from all 3 children that day. Once inside the jury room, they refused to interact with or even look at their father. The court met with the children several times that day in an effort to encourage them, but ultimately had to order them to see their father, which is well within the court's authority. The issues with parenting have been ongoing for the past 5 years, as have efforts to assist the family with therapeutic and supportive services. Father filed his motion for an order to show cause mother on March 23rd of this year as to all of mother's parenting time violations. Mother agreed following the filing of that motion to spend the day in detention and to spend additional time volunteering at an animal shelter. This court again witnessed disturbing behavior displayed by these children on June 24th. Following yet another failed attempt at meaningful parenting time with their father, the children's guardian ad litem, the parenting time coordinator, and the family counselor in the jury room, this court ordered the children to have lunch with their father and speak with him. Each child refused and indicated they would rather go to Children's Village than spend time interacting with their father. While it came under a contempt of court ruling, my intention was, and continues to be, for these 3 children to receive independent, objective, and caring counseling outside the influence of both parents. These 3 children are not being punished. They have been removed from a home situation in which they were unable to pursue a healthy relationship with their father. They have been evaluated by no less than 5 independent professionals in the past 5 years. This court appointed the guardian ad litem 5 years ago to assist with these children, to help their best interests be heard. Every alternate avenue presented to this court has been exhausted. This includes many parenting time supervisors, therapeutic parenting time in each parent's home, parenting time in public setting, and Skypes with the father. Each attempt has been met with resistance from the children, refusal to acknowledge the father, and complete disregard for the authority of the court. These children are unable to understand their need for healthy and productive relationships with both of their parents. Contrary to what has been reported, these children have not been locked up, and they are not placed with juvenile offenders. Rather, they are in Mandy's place, a non-secure, safe environment on the grounds of Children's Village, where children from difficult circumstances receive outstanding residential, mental health care, and other services. Mandy's place is for emergency placement for children who have no next of kin, no foster care designation, or need temporary placement. The children are able to participate in fun activities, including field trips. They attend school and interact with other children. Mandy Place reports that in the few days they have been there, the children are interacting with other children, participating in fun activities. Their counselor indicates they are making progress. This is the first progress for these children in the duration of this 5-year-long divorce case, and the evidence that the decision to place them and evidence the decision to place them at Mandy's Place is serving its intended purpose. Mandy's Place has the resources to get these children on track. While it is clear that these parents are unable to effectively co-parent, the goal for these children is for them to develop healthy and sustainable relationships with both parents. Having such relationships would undoubtedly benefit them for the rest of their lives. No matter what animosity may exist between these parents, their first thought should always be about maintaining a healthy, loving, and stable environment for the kids. This includes supporting a relationship with the other parent. Until these parents are capable of doing so, this court will remain vigilant for the children's well-being and make every ruling in their best interest. So having said that, where is Ms. Kelso here? Ms. Kelso, if you could please approach the podium. Would you please state your name for the record?
Brittany Kelso.
Where do you work?
I work at Oakland County Children's Village, specifically in Mandy's Place.
All right. Well, can you describe Mandy's Place to the court?
Mandy's Place is an open setting. It's a residential building where children, as you've already stated, come to stay because they have no other placement. Once they're there, they receive ongoing care in regards to some medical needs. They receive dental services. They receive recreational services, as well as mental health services. We also do several different options in regards to school. Currently, all three of the children are attending summer school through our Children's Village School, which is ran through Waterford Public Schools.
Right. Can you tell me how often do you see the children?
I see the children nearly daily. They interact.
How are they doing?
They're doing very well. They're doing very well.
What do you mean by
They
that?
seem to be making progress on a daily measure. Each day they interact with their peers, they're laughing, they interact with the adult staff members, they're smiling. We have been working with them on a therapeutic level in therapy to, again, try and home in on the relationship with the father. And so, again, it's going to be a slow but hopefully steady progress. But right now the children all three of them are stable. They seem to be enjoying their time with their peers as well as the other adults. They're enjoying things such as barbecues, going on nature hikes, doing an art program. And, Your Honor, you arranged for the Canine Advocacy Program to come over because the children love animals. And so the kids really appreciated that, and I want to thank you from them that they enjoyed that.
Right. Thank you very much.
You're very
welcome.
welcome.
Appreciate you informing the parties.
Yes.
Next, the attorney for the children and the guardian. Has there been any progress?
Thank you, Your Honor. Michael Dean on behalf of Rowie as well as Natalie. I did visit with the children yesterday. I will indicate, in my discussions with them, they basically stated that their needs are being met on a daily basis in terms of their health as well as their getting daily meals. That being said, Your Honor, I did meet with them right before we came out here, told them about today's proceedings, asked them in terms of their placement. They both indicated that they would like to return home to mother and that they still would not want to talk with their father at this time, have no relationship with him.
Right.
Thank you.
All right, Mr. Schwartz.
Good afternoon, Your Honor. Jeffrey Schwartz on behalf of Liam. I've had a discussion with Liam. He as well had indicated that he's doing fine and he's being treated fine. He has indicated to me, well actually I had a long discussion with him about what my role was, and I indicated to him that I'm his advocate, and when I get the chance to I would advocate for his release. He too wishes to go back with his mother. He indicates at this time that he still maintains his position concerning the relationship with his father, and that at least at this point has not changed. That's about all I can report at this point, Your Honor, but I will have continuing discussions with him. I think he expected, and the court has made it clear that you're not going to hear that motion today, so I'll let him know that, so he'll have some more time to think about his position, and then we'll go from there.
All right, thank you. Mr. Lanson?
Your Honor,
Can you report on the progress, or what has happened?
well, I want to say to the court first that I've seen them every week. The one that I thought made a little bit of progress has been Liam in talking with me, in understanding that he doesn't belong there. He shouldn't be there. Neither one of them should be there. I've told them nobody wants them there. They should be starting school. They should be doing other things. Liam, I think, was a little more receptive. He appeared open to working with the court, maybe trying to see his father privately, trying to talk, trying to have some eye contact. He would try. We can't obviously move his mouth for him or tell him how to feel or tell him how to think, but he was a little more open to that. And based on that conversation on Wednesday, I told him I would call the court and see, I think it was Wednesday, call the court and see if I could bring this matter in sooner. I did, and the court set today. And I told that to Liam, that I did that. I don't know if his position has been changed with his attorney. So, and by the way, Judge, we have been talking over the week and a half, 2 weeks, all of the attorneys to try to come up with some plans. So we have been doing that, and I will make that suggestion. I do want to say, Your Honor, that the court appointed me after there was a motion filed on a Wednesday 5 years ago in August by the father for unsupervised parenting time. You granted it. And then you appointed me, said try to, GAL, work out a plan. I didn't know much about the case. I know that mother was extremely upset at the time. She thought that the father was going to take the children to Israel, all this and all that, and she was very upset. And I said, well, go back in there with your attorney, work out something maybe with passports and something like that. She did, but she was very, very emotional, very upset. The 4 days that he really maybe had 1 or 2 days of unsupervised parenting time. After that, I was on the phone Thursday, Friday, and Saturday with either the police, protective services being called, the children calling 911, father reporting mother was sending neighbors there. And so eventually I had to tell the police, then you need to stop the parenting time and I have to get a supervisor in there. This isn't working. So it was sabotaged. Now, after that, for 5 years, Judge, we have tried everything that mother has asked us to do. We have tried every form of supervisor, every form of therapist, every form of counselor, psychological evaluations, parent evaluations, $10,000 report, and tried to do what mother wanted us to do. We tried dogs in the car. We tried a year of a counselor in the home with mother and the father with the children. Every time mother has proposed something, we've tried to work with her. A neighbor friend of hers, we put the kids there. We've tried everything. For a period of time, mother never even appeared at court hearings until you told her she needed to come. Nothing worked. And it came to the point where I think it was a 30-page report where I basically said to the court, I laid it out. I said, we can't counsel this case. We can't therapy this case. The behaviors are very disturbing with the children. I firmly believe that mother believes that it is appropriate behavior of these children to react this way to adults and to the father. I think she sees there's no issue with it whatsoever and not a problem. She supports it. This is part of the problems of these kids. I think the damage is so severe. It's very sad. Very, very sad. A year ago, when we came before this court, and the court finally had a chance to see it, that when those kids were outside, you had no less than 6 deputies. Those children huddled together, tapping their feet, sending messages to themselves. They wouldn't even talk to a deputy with a gun. Mother did nothing. An hour went by, all these deputies. Your friend of the court counselor. The behaviors were frightening. It doesn't take a PhD to figure out that there's something wrong going on with these children as it relates to their father. But how children talk to you, talk to the family counselor, forget me, talk to sheriffs, unbelievable. And mother simply had no affect and was unfazed by it. You brought her in here twice, and you said, stop this, or you're going to go to jail. Didn't bother her. I think after that there was a motion hearing where you at that point in time said, I'm going to change custody. I'm doing it right now. You were prepared to do it. I said, no, I don't think that's what we should do with these kids. Maybe that was a mistake on my part, but I didn't think that was the right thing at that time. To your credit, you tried to fashion a remedy to try to help these children. You can debate whether it's legal, not legal, whether you can do it or not, fine. But what strikes me, Judge, is that there is nothing in Mother's pleading to this court that would have said the following. I disagree with what the court did. I believe legally it was wrong, whatever. Having said that, I do not think that the children's behaviors are appropriate to adults, to their father, or anyone else. Let's try to work this out. I don't see that anywhere. And by the way, with counseling, that has never worked because one or two times the mother would take them, they wouldn't even get out of the waiting room to get in to see the counselor. Mother argues to the court at one of these hearings that, oh, these kids are traumatized by their dad. They did this and then that. And then on the same breath they say, but we don't want counseling. We don't want to address it. My concern is how are we going to try to foster a normal, healthy relationship as they grow older for adults? I agree. We're not going to be able to force these children, Judge, to talk, move their mouth, love their father, not love their father. They have thoughts. I understand that. I do not believe they belong in the children's village. The children shouldn't be in the children's village. So one particular plan here today, okay, has to involve taking them out of the village, but it does not involve the mother. They cannot go back to this mother. So you can either do one or two things. Send them to Camp Tamarack overnight for a couple of weeks. They can go to an overnight camp, be away from everybody for a period of time, which would probably be very good for them. And then there is a woman that we have identified that would come into town to try to do extensive reunification. That's one option. The other option is there's a day camp at the JCC they could go every day. They'd have to find a different place to stay. And we get them into intensive counseling on a daily basis. I'm not optimistic that counseling is going to work. It might work if mother is not involved. I have to say this, Judge, to mothers. I've not talked to anybody in this case. I don't know this lawyer that she's got in New York, and that's something that they'll have to deal with. And I don't talk to the media because it's very sensitive. I want a protective order that mother is not to put these children on any social media. If you can get an order to remove their faces from the social media, that needs to be done. I think it's outrageous to have done that to these children. They don't need it. And all mother could have done is come before this court and say, I disagree with everything you said, Judge, but having said that, their behaviors are untenable. Let's try to fix it. You're not going to hear that because she doesn't believe it. And as a matter of fact, Judge, I do think that the one time that the child was in father's apartment, we had a hearing about that, when you had a trained, I think he's an ex-police officer, that mother found 2 years ago for supervision. I think the story that the child said was so outrageous and so different than what was observed. It was unbelievable. And I believe that mother told the child what to say, and that was the story, so she could sabotage them ever going to fathers. You got to give mother credit. Whatever she did all these 5 years, she's been successful at it, and she's been on a campaign, and she's won to some extent, and she has damaged these children. And, you know, mother, God bless you. You've succeeded in that. So I think it's a travesty. I want them out of the village. They don't belong there. Come up with a plan. If not, Judge, you have authority to do something. But they really need to be out. And let's try to come up with something. But it cannot involve the mother at this time.
Very good. So do you have an option?
Yes, Your Honor, I discussed my plan and actually have made extensive efforts to try to secure a better option for these kids. I have talked to Ms. Stern about it. I have been in contact with Mr. Lancet for days on end, frankly, even over my own vacation, trying to figure out something. It was my suggestion that the children perhaps go to Camp Tamarack. I'm reluctant to talk about it too much because, quite frankly, I don't want this to end up in the press because it does not serve their best interests to talk about where the kids might be placed or what have you. And I'll address that further in a moment. But I have talked to the officials, the Jewish Federation, and Tamarack to be able to get these kids in today, tomorrow. They're already in mid-session. I think I'm hoping that they will agree. I'm waiting for a call back, but I'm 99.9% sure this is the viable option for them if the court agrees. Time and again, I have discussed with my client about filing a motion to change custody. But I can't have 3 kids that go back to my client to make all sorts of false allegations run away, do what have you. That's not in their best interest. I will tell you that given the turn of events, we had sincerely hoped that this time at Mandy's Place in shelter care would bring them around a bit. And while I think some progress has been made, 5 years of damage isn't going to be undone in 2 weeks. So I will indicate I am going to file a motion for change of custody forthwith, but quite frankly, given the flurry that has gone on in the last 2 weeks, the motions, the appeals that have been filed, just hasn't been done yet. I am going to file it forthwith. In the meantime, on behalf of my client, I am asking that you allow the kids to go to Camp Tamarack. This court entered an order on June 23rd and one even prior about a reunification program. I filed a motion in February and again in March to show cause mom for her umpteen violations that I am not going to belabor again, as I've already gone over them dozens of times in this courtroom, of how she does not foster a relationship and how she does everything she can to meddle, obstruct, or ruin whatever love these children may have had for my client. This used to be a loving family. He lived with them. They loved him. And it's gone. It's gone. So I am going to file that motion, and I am going to ask for my client to have sole legal and physical custody. But the truth of the matter is, they'll run away from him if you put them there right now. So consistent with the court's order of June 23rd, I want them to go to a parental alienation program. We have been in contact with, when I say we, myself, Mr. Lancet, all sorts of various programs. One they were not accepted in. One I think there's no opening, but there are a couple others where they come here to this state, a team. Nothing has been secured, but I do know that there is some availability. And of course I'd like to be in consultation with Ms. Stern on that, Mr. Lancet. But my hope is that perhaps they can go to Camp Tamarack, and from there immediately they can go right to a parental alienation program. Frankly, the good programs would require a workshop scenario where the children and my client would go, and then there is an aftercare program. My hope is in the meantime that the court would grant a hearing on my motion to change custody, and we will work out where the children go after that program at an evidentiary hearing. I think it's the most viable plan that I could come up with, and talking to officials to try to work that out. In the meantime, I also want to ask the court for a protective order. I know Mr. Lancet received correspondence from a woman by the name of Jennifer Holt, who alleges herself to be a New York attorney. She's gone out into various media outlets representing that she represents the children, and she actually ordered in her correspondence that Mr. Lancet, Mr. Dean, Mr. Schwartz, and Ms. Cook could not speak to her clients. Well, I'll tell you something. My client is the joint legal custodian of these kids, and while he may not have physical custody, he has all sorts of authority with regard to medical decisions, educational decisions, religious decisions, and what lawyers are retained on his children's behalf. He never consented to this woman representing his lawyers. I don't know who this woman is. She has never spoken to me. She's just sending letters out forbidding these court-appointed lawyers to talking with her clients. It's disgusting. She's not licensed here in Michigan. I know nothing of a federal lawsuit. My client knows nothing of a federal lawsuit. If there's one filed, I want to know about it immediately. But I am asking that this court enter an order that Dr. Ibschitz-Simoni be precluded from retaining counsel or hiring any professional on the children's behalf without my client's consultation and consent. Likewise, I am so disturbed that any media outlet would put a photograph up of these children. I personally drafted a press release on behalf of my client and indicated, I'm not trying this case in the media, I'll try this case here before you, Your Honor. But I said, you do not have my client's permission to publish photographs on social media, put them on television, put them in newspapers. My client will not be able to go to dinner with his children in our community without being recognized. How is that in their best interest? It's disgusting. It's disgusting. I'm asking for a protective order, Your Honor.
Thank you, Your Honor. Your Honor, as to the issue of the New York attorney that obviously none of us have met, none of us know, that is a federal issue, and actually I don't believe that this court can enter any order as to her representation of the children. That issue does have to play out in a federal court. There is law on point that also says even prior that 1983 action does not have to be filed but that one of two parents, you don't have to have consent from other parent to have the other hire on behalf of minor children an attorney for a 1983 action, because to do so would be to cut them off at the knees. So the reality is the federal law is very clear on it, and we don't need to argue it in this courtroom. This is not the proper jurisdiction. We understand that there are issues with it, that there are attorneys not in this courtroom, not in the state getting involved, but I don't believe that this is the forum that can or should make an order as to that issue. As to the rest of it, it's all properly before Your Honor today. I'm not quite sure. You started these proceedings by saying that we were not arguing on the motion for reconsideration, yet there's been all sorts of discussion from all the attorneys that they did not want the children in Mandy's place any longer, and that they were going to be taken out, if you would so order, removed from that facility and put into another location.
What is
Mother's position on that, again, is more of a legal issue, Your Honor, in that there's no custody case before this court. Neither party, since the date of the judgment of divorce, has filed a custody action in front of Your Honor, which means that the broad ability and the broad powers awarded to this court under the Custody Act do not apply. In fact, if you look at the Custody Act, as we all know quite well in this courtroom, it indicates that an action has to exist, either through this court, through the filing of a custody act itself, or arisen incidentally from another action in the circuit court, which is typically, like as we know, a probate proceeding.
My question is very simple. What's her alternative?
Her alternative is not an alternative. Well, it's for the kids to come home to her. She does agree that this court did order a reunification program for the children. And that program, the reason they haven't started is because counsel prior to me, no one had found one that was available. And it seems like Counsel for Father has done an excellent job in finding a woman who can come to Michigan, be with the children and father for about 5 days and 4 nights, and it seems to be a viable and economically wise program for these children to get into immediately, or as soon as that woman is available. As far as placement, Your Honor, I don't believe that this court has any authority at this point to do anything other than to return the children to their mother. Again, there's no custody case pending so that we can put these children in the care and custody of a third party. This is not a foster care proceeding. We cannot put these children in foster care. And
So
even
her alternative is return home. Is that what you're saying?
is for to be
All right.
returned home.
Mr. Lancet, do you have anything else you'd like to say? What is your recommendation as the advocate for these children?
My recommendation is I would like to see these children out of Children's Village ASAP. I don't think they belong there, not in their best interest at this point in time. I don't think that they need to do there. We need to come up with a plan. I do think you have authority. They can get their petition in should father want to pursue it. I think you do have some emergency orders under the Child Custody Act. There is a dispute because the parties can't agree, so it is submitted to you. You have jurisdiction. So I think that I'd like to see them out. I would like to see them either go to Camp Tamarack. Today they have transportation they can enjoy, have a couple weeks in Camp Tamarack. Or you get them out, they can go to the JCC every single day, but they cannot, they have to be removed from the mother for a period of time. I will tell you what was disturbing. When we were here 3 weeks ago, when Mother said to me, 2 weeks ago, when Mother said to me, can I go back there and see Roy with her attorney? I said, sure, I'll bring you back there. So she goes in there, and then I find out she's talking Hebrew to them. When Mr. Dean didn't understand Hebrew. And so this is the stuff that she's communicating to these children and has ingrained into them that this is the most dangerous, violent man. Well, if these children have these issues, then you try to work it out therapeutically. You don't stop the therapeutic process, which has been in the case over and over again here. Maybe therapy might work without Mother's involvement. I want them out. I want to come up with a plan. I do want them out.
Can I respond, Your Honor, to the legal argument? My client is the joint legal custodian. He's asking for his kids to go to camp. It's that simple. You can make the call. It's not a change of custody or anything else. That determination will be made in the coming weeks. But it's not a legal issue. I mean, my client is asking for permission for his kids to be allowed to go to camp. There's no problem there. You can make that call.
And Your Honor, as to that, whether or not a child can go to camp is not a joint legal custody issue before the court. If those are major life decisions, education, medical, that does not fall within the purview or under the parameters of a joint legal custody issue. The other issue would be is if they are going to Tamarack, and if it's at Dad's request, is Dad paying for that program? That program comes at a cost. These are issues that the court would have to decide then today.
All right, the court is going to take a brief recess.
Thank you.
All rise.